There we go. This, I almost forgot. This will be recorded and placed on our YouTube channel for anybody to review later on. Kay, I'm going to go ahead and turn it over to you.
Okay, so this is where I push that little button that says share screen. Yes. Screen 2. Share. You should see a pink and white panel there. Yes, Amy, we're good?
Yes, we are good.
Perfect. So thank you for that introduction. Yeah, the judicial JARC is what we call it. I added that because I'm really excited. You know, it's an honor to be asked, hey, when we appoint a new judge, we'd like your input on it. And it's like, wow, thank you. Yes, I'll tell you what I think of these people. So I haven't done it yet, but I'm very excited about that position. And so I am Kay Hyde-Patton. I have been doing this for a while. Thank you for reminding me, 19 years. First of all, I just wanted to thank you, Evergreen Title, for your assistance in matters. Our firm has worked with y'all for many years and appreciate your integrity and persistence in doing a good job. And even though Joe Leahy has retired, we look to have a future with y'all just working on matters. Today, I will, let's see, push that button. There we go. This is a brief overview. We are going to be talking about Oregon law because I am an Oregon attorney. That's where I am licensed. I don't know what California or Arizona or Washington does, at least not enough to advise you on it. And Oregon each state has its own estate law, and Oregon has statutes that affect probate and small estate affidavit, which is our focus today. Now, this is a general overview. The statutes that cover probate law are actually 9 chapters long, and the intricacies are about 2 volumes of law. So I'm not going to get into the weeds, but we'll do a general overview. And let's discuss questions. I think Amy's going to be fielding the questions through chat, and we'll get to them as soon as we can. So please feel free to put those questions in there, and we'll hopefully timely answer them. Probate and small estate affidavits are court proceedings, and the purpose is to convey assets that are owned by a decedent to the living, the survivors. Within that process, the focus is to pay the bills, pay the taxes, and distribute those assets. So when the people receive those assets, they don't have to worry about, well, is the IRS going to come after me, or is that creditor going to come after me? Because all of that has been done. They can just take their proceeds and move on with their lives. So today we'll talk about some terms, those proceedings, and just a smidgen of trust, because I know everybody goes, yeah, but what about if it's owned by a trust? Well, we're not going to cover that, but we'll just briefly have one little slide on that. So quickly, terms. Probate and small estate affidavit are the 2 court proceedings that we're going to discuss in detail. I like to talk about the people that are involved, and I probably should have rearranged these. Affiant goes with small estate affidavit. Personal representative goes with probate. And then if you have a trust involved, and sometimes you do, a testamentary trust and a will, you may have a trustee too. Those are all the fiduciaries, and we'll talk about those in a little more. Then you've got the recipients, a beneficiary, an heir, and a devisee. So a beneficiary is anyone that receives assets or proceeds from those assets. An heir is actually statute. We have statutes that tell you, are you an heir? And those are your people that are either biologically related, or they're adopted, and that's an heir, and there's law on that. Are you or are you not an heir, and how much do you get? The difference between the heir and the devisee is important to note because people think they're interchangeable, and they're not. The devisee are the people that are listed in the will. So if there is a will, I say I want everything to go to my kids. Well, my kids are not only my heirs, now they are devisees. And that is important because the next two terms is testate and intestate. Testate means with a will, so we have to follow the will and the writing of the person that wrote it, the testator or the testatrix, depending if you're male or female. And then intestate just means without a will. So now we're just looking at those heirs, and we don't have to worry about any devisees. So small estate affidavits, and I like to call them simple estates. There is only one section within the 9 chapters that talk about small estate affidavits. And these are the criteria that you need to meet. 1, 2, and 3 are statute driven, and number 4 is in my mind, and we'll get there. So assets that need to be probated. So if you have assets that are owned in a deceased person's name only, one name, person is deceased, and there is no beneficiary designation on that asset, there's no POD, pay on death, no TOD, transfer on death, then you have assets that you don't have access to. You go to the bank and say, I'd like this money, and they're like, well, I'm sorry, that was in the decedent's name. Well, how do we get access? And so a small estate is helpful if those are the type of assets that need to be accessed. And then real property cannot be more than 200,000 in value. And the other assets can't be over 75,000. And then I always add a simple estate. So let's just take these piece by piece. For the real property, we have to go by the fair market value, and I'm sure all of y'all know what that is. But the courts say that we can use 3 different pieces to determine that fair market value. We can use an RLID, the county information, not the assessed value, the fair market value that the county uses. We can use a realtor, do a comparative market analysis, or we can actually pay for an appraisal and have someone come out and give us a value that way. For the small estate affidavit, we use the date of death value, not 6 months later, not 6 months before, but the date of death value. However, there's one little piece to that. If you don't file that small estate affidavit until a year after the person's dead or longer, then you have to use the value within 45 days of the filing. So grandma died 2018. Now I want to do a small estate affidavit. You have to get a new fair market value, and that will be the value that you use on the affidavit. Other assets. Personal tangible property, you can include that on a small estate affidavit. Vehicles, furniture, things that are household items. It also includes intangibles, bank accounts, investment accounts, annuities. All of these are included in number 3, and if they add up to more than 75,000, you're over in probate. So we need it under 75,000. And then the last one, if it looks like you've got a bunch of people fighting over the couch, or if we don't agree whether this will is the right will, or if we just have a bunch of people that aren't getting along, a small estate affidavit is not the place to file. I bump it onto probate because that way we have more filings and more ability to address those issues. But if it looks like we all get along, yep, we're going to follow grandma's will, you can file a small estate affidavit. And let's look at why would you do that? Benefits for filing a small estate affidavit. One filing is all that's required to open the estate, to file with the court, and provide authorization of the applicant to administer those assets. You are going to list the assets that are needed to be administered in that document. There may be other filings, but they're minimal compared to probate. A creditor might file a claim against the estate. Well, you have to address that. But usually it's one document, one and done. The affiant, the person that can actually file the small estate affidavit, can be an heir, can be a devisee. So we've already talked about those. Heir is biological or adopted related to the decedent. Devisee is named in the will. In the will, people nominate the person they want to be their personal representative. That person can be an affiant, or it can also be a creditor that says, hey, grandma owed me some money. How am I going to get that money? So creditors can actually be an affiant. Another benefit is less cost. Right now, the filing fee in Oregon is $124. That is significantly less than the probate filing. Also, the other couple of costs for a probate, you have a legal publication that you have to put in a regularly newspaper. So there's another cost in probate. You do not have to do that in a small estate affidavit. And there's no potential for a bond in a small estate affidavit. So there's another cost that you don't even have to worry about. And a benefit, some people would say, is no attorney required. You'll see at the bottom of this slide, the state of Oregon actually has put together a small estate affidavit online packet. And I printed it. I've got it right here. It is about 17 pages long. What I like about it is the first line says, talk to a lawyer if you do not understand your duties or any part of these instructions. And then line 2 says, if you make a mistake, you may have to pay personally the cost of the mistakes and any loss to the estate. Now, I don't know if anybody ever reads these, but the state did a very good job. It's 7 pages of instruction and then 10 pages of the form that's needed. So a reasonable person can probably do it. And of course, if you don't feel comfortable, then you can contact an attorney. The burdens. There are requirements of a small estate affidavit. You don't just fill out the form and file it and you're done. You are expected to send notice to all heirs and all devisees. You are expected to send copies to the state of Oregon, DHS, the state administration, so they can say whether they are owed money. And again, going back to, if you read the packet, you'll be fine. But a lot of people just want to fill out the form and move on. Entities accepting the small estate affidavit. So once you fill out that form, the small estate affidavit, you file it with the court and you get a stamp at the top. Here's your case number, and this is the day you filed it with the court. That's it. That's your formal notice that you are able to handle this estate. And even though we have statutes that say all entities must accept this as a court document, a lot of entities are hesitant to take it because they're like, but where's the official stamp, you know, and that's it. It's just a little thing at the top. So a lot of times people will file the small state affidavit, take it to the bank, and the bank's like, I don't know. So now what do? Well, you pull out the packet and go, look, it says you're supposed to take it. And they usually do. It just takes a little bit of a conversation. And then the burden is, okay, we filed the small estate affidavit. We've got a house for 175,000 and we got a bank account for 25,000. So we filed the small estate affidavit. Then 2 or 3 months into the small estate affidavit, we find another asset. Oh, we found a retirement account. Now we are over those rules. The 200,000, well, that one's okay. But the intangibles are over 75,000. You bump up to a probate. So it's not like you don't have options. It just means that you now have stepped up the game and you're going to have to do it anyway. So things to think about. The process of a small estate affidavit, once you filed that small estate affidavit, it has to, you're giving creditors notice and they get 4 months to file a claim against the estate. Known creditors will be listed in the small estate. Oh, the plumber, mom had a car loan that she had to pay. Those you have to pay, list in the small estate affidavit saying, yep, I know you're out there. But anybody that's unknown that isn't listed, they have 4 months. So again, that packet tells you very clearly, don't distribute anything for 4 months. Make sure you have all creditor information, but so you can pay those bills, pay those taxes, and then whatever's left, that's when you can distribute the assets. So, moving on. Probate. Probate is more extensive, more complicated. These are the 9 chapters that actually affect probate. And I just listed them so you can see how they're kind of broken up. No test over the test chapters or anything. The most, we'll just go. Chapter 111 is our court has authority to tell us what to do. Tell us as an attorney or personal representative. Got the wills chapter 112. Is it a will? Is it not a will? How to initiate the proceedings, 113. Just moving on, 116 is account, distribute, and close. The most recent chapter that was added was 119. That was a few years ago. Digital assets access. How do you get into Facebook or any other online stuff that were locking people out? Well, we made law and said we want access. So, benefit of doing probate. If it's not a small estate affidavit, or if it's a complicated small estate affidavit, then the probate proceeding is needed. Once authorized, the personal representative is authorized to administer all issues of the estate. And I wanted to go back to the personal representative and the affiant. These people are fiduciaries. And that word just means that the court has authorized this person to administer the estate. They have control over assets that are not theirs. It's someone else's. And which that means the court is particular about who actually can do that. We have law that says if you're a felon, you can be a personal representative. You have to just tell the court, you know, when was the act and what happened and what are you doing? If you were, well, I'm just going to leave it at that. Felon is questionable. If you're incapacitated, no. If you're a minor, no. And then there is even one for disbarred or suspended attorneys. I'm sure there was a case on that one sometime. And then a funeral director. If you're a funeral director, you've got to give a reason as to why you're going to be a personal representative. And again, the purpose for that is the court wants to make sure that these assets are going to be safe and taken care of for those that are going to receive it in the end. Probate is usually under the guide of an attorney. The attorney will be representing the personal representative. For me, I would think that's a benefit, because you just go to the attorney and say, help me. And sure, I do this all day long. This is what I do. If questions come up or issues come up, we deal with it, and we're there to support you. You'll also see, I was honest, I added attorney under burdens as well, because some people are like, that damn attorney. Every time I talk to them, they charge me money. Yeah, that's our job. But it just hopefully provides information and support for people that don't know the legal world. And again, we're trying to get you through that process as efficiently as possible. Cost, it's those things that I discussed under small estate affidavit. The filing fees are more expensive. I had those. I don't know what I did with them. $572, I think, is the first initial filing, and it goes up from there depending on how much is in the estate that's being probated. You also have to put it in a newspaper or a regularly published newsletter. I don't know, there's language in the statute that just basically, it's got to be a newspaper that's put out regularly. Your estate is going to be paying for that. And then going back to the bond, if there is a personal representative and the will states there will not be a bond, the court will recognize that. If there is no will and there is sufficient assets, the judge sometimes will waive it, but usually for the protection of creditors and for those other heirs or devisees, we'll put a bond on there. And as you know, bond is just insurance to make sure the personal representative runs off to Mexico with all the money, the heirs still have something to receive. When I do a probate, I have things I discuss. Here are 3 columns that are in my intake form, and you can find my intake form on the firm's website. You can either look up Leahy Cox, or you can look under emeraldlaw.com. Probate requires at least 6 filings. You've got the petition to open the probate, telling the court the potential personal representative, the size of the estate, name all the heirs, name all the devisees. Once the court appoints that personal representative, they send official letters of testamentary. That's for if there is a will, or letters of administration if there is no will. But you get an actual piece of paper that says this person has been authorized. You then have 30 days to provide notice to all heirs, devisees, and put it in the paper. And that has to be filed with the court. Yep, I did what I was supposed to do. You have 90 days, that's newer. It used to be just 60. We've extended it to 90 to file an actual inventory of those assets that are being probated. You have to describe the asset and give the fair market value on date of death within that inventory. That is signed by the personal representative and filed. Let's back up to notice. Once you've given notice or put it in the newspaper, depending on the date of those notices, That starts the clock for unknown creditors. They get 4 months to file a claim against the estate and say, hey, don't forget me. Once the 4-month window for creditors closes, within the 5th month is the 4th filing declaration of compliance. And that is the personal representative's checklist. And it's 2 pages long that the court has provided. Have you been checking the mail? Have you looked for creditors? Have you looked for assets? Have you checked the taxes? Is there a lawsuit that the decedent was involved in? Have you completed that or checked it out? Just a bunch of questions. And by filing this declaration, you have initialed each of those blanks and said, I have done my duty, that we are moving on. The court will not close the estate without that declaration. After those 4 months, if all the assets have been either liquidated or they're ready to be distributed, you file an accounting, and this is another cost to the probate. If you file an actual accounting with the court, they charge you a filing fee. There is a document called a verified statement in lieu of accounting. That means, hey, we're all a happy family. We all get along and we all sign consents. And we're ready to distribute. You can file a verified statement and there is no cost to the estate. With that final accounting, you're asking the court permission to distribute the assets. And I say, Mother, may I, because Judge Holland is our probate judge, and I say, Mother, may I please distribute the assets? And she either says yes or no. Please note, if a year from opening this estate, it is not ready, and surprisingly, a year goes very quickly when someone dies, and you may have some complicated assets or issues to deal with. You have to file an annual accounting each year, tell the court what's going on, what's the issue, and it better be a doggone good reason. You get 1 year, pretty easy pass. 2nd year, but 3rd year, you better know what you're doing. We are not California. We don't let this stuff go on and on and on. And then the 6th filing is receipts, and discharge and close. The recipients have to say, yes, I received my share of the estate or my whatever it is. And then you ask the court to discharge the personal representative and close the estate. And we get the last judgment, and that file is closed with the court. Now, there may be other filings, just like I said in the small estate affidavit. If a creditor files a claim with the estate saying, I think they owe me money, you can disallow it. You can look at it and say, I don't know who you are or what you want, but this is not true. Or you can file an allowance and say, yep, oh, sorry, we forgot you, thank you for letting us know. You don't have to file an allowance. If you don't file an allowance within 30 days of receiving that claim, it is automatically expected you're going to pay it. Sometimes we get to that end of the 1st year. We've got a few assets that we want to distribute, but we haven't finished the whole estate. You can file a motion for partial distribution. The judge gets to decide whether she determines this is a good time to distribute part of the assets. Sometimes you need an actual motion to sell property. That's a special situation, but sometimes. So there's the required filings, and then there's sometimes other things that need to be done. Duties of the personal representative. This is for the affiant or personal representative. Just like I said, a fiduciary. These are not your assets. So take care of them. Be kind and protect them like a little mother hen. You don't commingle them with your assets. You find and preserve the assets that you find. You search for creditors. You tell the beneficiaries what's going on, and you do it all in a timely manner. Those are all duties that can be litigated. That means a beneficiary doesn't think you're doing what you're supposed to be doing. They can bring a case against you. I'm afraid of Judge Holland. So We don't have a problem there. We're going to do our job. Potential taxes, like I said, pay the bills, pay the taxes, and then distribute. These are all the potential taxes that the personal representative or affiant needs to look at. Affiant, well, let's take them one at a time. Individual, depending on when the person died, did they make enough income within that year that they need to file their own tax return for that year? I don't make that determination. I tell you to go talk to your accountant and have them review the information, but it has to be addressed. Fiduciary. So once the person dies, any income coming to that person after the date of death, now it is their estate's income. And if it's enough, the estate may need to file its own tax return while you're a personal representative, and that's the fiduciary tax return. Then there's the estate tax, and in Oregon, we have the Oregon estate tax. Federal right now is 12.2 million per person. I don't have a lot of clients that have to worry about that, but the 1 million for Oregon comes up regularly. And so that needs to be addressed, and whether we need to file an Oregon estate tax return, which is a 706, OR 706. And then the last potential tax is capital gains. And I'm sure y'all know all about capital gains. A person dies, we have a fair market value on the date of death, but that can change if you sell that property within 6 months of the date of death. Then we assume the fair market value was actually that sale price, which is good for the personal representative. They don't have to file tax. However, if you have a fair market value on date of death, 250, and you sell it a year after death for 300, now you need to talk to the tax person and make sure that a capital gains is being addressed. And that's all I'm going to say about taxes. So we are getting to 10:40, and I am very proud of myself because I think I'm getting close to being done. Amy, how are we doing on questions? I don't see anything.
Sorry, I was muted. So far, there are no questions in the chat box.
That's
and
great.
If you guys have any questions, oh, we have a question. Can you repeat the part on the last comment of fair market?
The capital gains. So fair market value, date of death. If I use real property because that's what we're dealing with. Grandma has a house. We say date of death, fair market value is $250,000. We are in the probate world. If you sell it 4 months after she dies, oh, well, actually the court realizes that to be the fair market value, whatever it was. So, oh, we sell it for $300,000. Now that is your fair market value, and we don't have to worry about capital gains. However, if you sell it for $300,000 a year after grandma's date of death, now you've got a $50,000 difference between the fair market value date of death and the actual sell price. And there's potential capital gains. I don't always say there is, but could be. And that's when you need to talk to the tax person. I hope that answers their question.
Yeah. And we have another question. Can you discuss stepped up basis?
That is it. The fair market value of date of death is the step up in basis. So it's what was its value on date of death. It's not what they purchased it for in 1966. It's not the purchase price plus items that they've repaired or upgraded. Just date of death. What is that value? And that is your basis. That becomes your automatic basis for those properties.
Okay, and then one more, and then we'll go ahead and start back up. Does a TOD deed help move everything into a SEA instead of a full probate.
So a transfer on death deed is a whole nother animal. They are best, and I'm not saying you can't, but they are best if grandma's house is going to someone and they don't expect to sell it because title companies in Oregon have decided the statute reads the creditor has a right to 18 months to file a claim against that estate. Therefore, you can't sell it for 18 months, at least under the transfer on death deed. So if you have a transfer on death deed, but you want to sell it quickly, you have the option of going small estate affidavit or probate. And really, you're just setting the transfer on death deed aside. And whether it's small estate affidavit or probate, it's the same rules. Is it under 200,000 or is it over? That's a really good question, but I didn't think about how it would affect. Let's go to the last slide, just so I can feel like next to last slide. Last slide of information. When I talked about the assets for a small estate affidavit or a probate being owned by the decedent as an individual, I get the question a lot. Yeah, but what if it was owned by the trust? Well, then we're not a small estate affidavit and we're not a probate. Now we're a trust matter. And that's a whole nother ball game. If there's a legal issue that needs to be addressed for the assets that are owned by the trust, then I hit them like this. You've got the trust agreement, always read it, see if it answers the question. If it doesn't answer it, or it doesn't answer it clear enough, because sometimes the writing may not be crystal clear, then we've got ORS Chapter 130. That is our default rules to fill in any gaps that the trust agreement may not have clarified. And then sometimes that isn't enough. And number 3, you can always file a court proceeding and request the judge to clarify either the language of the trust or the actions of the trustee or whatever is needing to be addressed. And that's all I'm going to say about trusts. But it is a piece and it is something that affects estates, and we have a lot of trusts. I would encourage anybody that has a trust issue, you need an attorney. So we've still got a few more minutes. I can talk about any of these issues a little more if you need it, but I do appreciate questions. I feel like I'm here for you. So I'm going to show you my last beautiful photo of all the beautiful attorneys in my firm and open it to questions.
So at this time, feel free, we do have one in the chat room, but I feel free to unmute and ask any questions that you might have. Yes, Sharon, you will be getting a copy of the slides from me. I'll be sending them out after this, as well as a link to the YouTube. And you'll get a separate email from Western Title and Escrow with your CE credit. Any questions?
I have a quick question, if you don't mind.
Yeah, go ahead and turn it up a little bit. Or maybe it's
Okay.
me. It's probably me.
No, it could be me.
Okay, there you go, Kim. I can hear you now.
All right, this is Kim Arscott. So with the raise in today's prices, and when you look at our lid and you have, say the house is listed at taxable, the real market value on the taxes is 250, but based on today's inventory, it sells for $100,000 over that. I know that's just what we do, but are we putting our clients in harm's way of having to pay additional capital gains because what the market sold it for, not what the tax records say?
So date of death value is one price. And then when you finally get the sale completed, you sold it for 100,000 more. Is that what you're saying, Kim?
Yeah.
Okay. I don't think harm's way, because you just benefited the beneficiaries by quite a bit more. That's 100,000 that may go to them. But it is the law.
Well, and I wasn't sure with the capital gains. Because
Yeah. It's that time, right? You've got 6 months to sell it, and then we recognize that value. If it's under 6 months, now that's the fair market value. If it's over 6 months, potential capital gains.
okay, so am I hearing that it's in the best interest of the estate to avoid those capital gains by selling it in the first 6 months?
Sure.
Okay. I do a lot of, I have my probate certificate. So I do a lot of probate, but sometimes I forget to ask those questions. So thank you.
Yeah. Yeah. Yes, I agree. And it's always measure, right? If you're only going to sell it for 10,000 more, but you could sell it for more, right? I mean, it's weighing, how much are you selling them for? How much are those taxes? Yeah. Conversation to be had.
That's all I had. Thank you.
Any other questions? Great question, Kim.
Yeah. I would encourage you to go to the website for the state of Oregon, the small estate affidavit. I know as realtors, what does a house for less than 200,000 look like these days? It doesn't feel like much sells for anything under that, but this is a good packet. And if anything, it defines language. It sets out what the requirements of a fiduciary. It's just really well written. I'm very impressed. So it's like a very good source to have in your back pocket there.
It seems like there were a couple of questions in the chat that haven't been answered yet.
Oh, did I miss them? Let's see. Can you repeat the part about the last comment about the fair market value? We addressed that one. Can you discuss step up base, which was the same question as the first? And does TOD deed help move? Got that one. Can we get a copy of the slides? I don't think, which one are you seeing, Kathy?
Oh, do you know what a holographic will is? And the other question is, I've heard that if you set up a revocable living trust, then nobody can change it. Can assault the court and say that a challenge that's what I'm looking for. Yeah, nobody can challenge the estate like you can with probate.
Okay, well, let's start with holographic will. Holographic will is a handwritten will. Oregon does not recognize handwritten wills, never have. There is a window now. We have a new statute, ORS 112238, and it is the exception to the will execution formalities. And basically, it states that if the testator intended for this writing to be a will, and you have clear and convincing evidence that the testator meant that this was a writing intended to be a will, you can provide that to the court and allow the judge to determine, is this a will? And that's new, and that's good, because sometimes it's pretty clear. The former rules they're very strict. You got to have 2 witnesses. The witnesses have to sign the affidavit of attestation. They have to be notarized saying over 18 of sound mind and intent to create a will. And if all that isn't done, then it's not recognized as a will. And that's the problem with holographic wills, is you didn't have all of the signing process part of it, but now we have 112238 and we'll see, with all new law, we have to have cases to determine what exactly is accepted. And we will see. The second part, Amy, help me with that. Can you paraphrase or have someone paraphrase what was the question?
Kathy, do you mind repeating it?
Yes, I was hearing that if you have a revocable living trust, then it can't be challenged by somebody who says that I'm supposed to get $50,000. But you can challenge probate, but you really can't challenge the revocable living trust.
Well, that's a loaded question, so I'm pausing here to make it clear. A will can have an interim provision in it, which says you get what you get, and if you don't like it and you file something saying you get more, you're out. That's a no contest provision, interim. And that can be in a will. And that means you can file something and say, I don't like it, but the will says if you do that, you're out. Revocable living trust can have the same interim provision, a no contest provision. But other than that, we live in the United States. You can pretty much file a lawsuit for anything. So if you have still a question on that, I'm not being flippant, but there's a lot of issues there and probably facts that need to be discussed. So if you want to email me or call me, maybe we could talk a little more to one-on-one about that. Good questions. Yeah, trusts. That's a whole nother animal. Amy, I don't know if you're going to have anybody talk about trusts or how that works and how assets are owned by trusts, but that's a great topic.
Okay. We will remember that for a future class. And for those of you on any topics that you guys are looking for, send us, because I'm scheduling them. Anything else out there?
I think trust would be really good because a lot of our clients are, selling properties or buying them in a trust. So I think that'd be a great class.
Okay.
And lots of facets. Capacitated, incapacitated, deceased. Yeah, lots of fun stuff. Well, we still got a few minutes.
Anything else? Anybody?
Go ahead.
Oh, Gary. Oh, thank you, Gary. He also says it'd be a great class to do. I do want to tell you guys all to mark your calendar for our next Western Ed Wednesday, which will be on the 20th, and we'll be having presentation by Strategic Mortgage. So be looking for that. It'll be in my wrap-up email after this. Getting lots of thank yous, Kay, in the chat box.
Thank you.
And I'm going to go ahead and stop recording. Sorry.